A very good evening to one and all present here. As you know that today, the webinar is exclusively available for YIAMC members. YIAMC, the Young IMC members, is a part of our capacity building initiative. And the theme for the webinar today is Emergency Arbitration Unravelled, an exploration of strategies for swift resolution. So basically, the topic today is on emergency arbitration and the nuances surrounding it. Today, we have amongst us Mr. Niels Schiersing, who is a dual qualified lawyer, both in civil and common law, and is a full-time international commercial arbitrator specializing in contract law and arbitration law. He has acted as an arbitrator in approximately 100 arbitrations with seats in Europe, Asia, Africa, in subject matters ranging from construction and engineering, energy and resources, banking and finance, commercial chancery, reinsurance and insurance, licensing, distribution and agency to competition law and state aid. He has extensive experience as an emergency arbitrator, and his offices are located in London, Dubai, and Hong Kong. I now request Mr. Schiersing to please share his invaluable insights with us today, and I warmly welcome you on behalf of the entire team of IAMC.
Subha Madhyanam, thank you so much for inviting me to speak with you today. I hope I didn't butcher that introduction too badly. My housekeeper is from Hyderabad, and I asked her how to introduce myself in a more formal way in her language. Thank you for those the kind words about my merits and my qualifications. I sit as arbitrator, as mentioned, across 3 continents, Europe, Asia, and Africa. And wherever I go as an arbitrator, I often encounter Indian parties. I have sat as arbitrator in India. In fact, I belong to the, I think, rather small group of arbitrators who have sat as presiding arbitrator in an LCIA India arbitration. And India remains a main focus for my endeavors as an arbitrator, and it is my sincere hope that I will be able to further develop my ties with India and the Indian legal community and Indian arbitration over the coming years. Sitting as an arbitrator, I've noted that Indian parties and Indian counsel are very sophisticated, and they're very well versed in procedural matters as well as in the substantive law of the lex causa of any particular matter. Turning to today's topic, which is emergency arbitrations, I intend to spend approximately 30 minutes giving you an overview of some of the pertinent issues related to emergency arbitrations, both procedurally and substantively. And following that, I'll be happy to take any questions that you may have. I'm keen to make this an interactive event. In my address or speech, I will focus on the matters that come before the emergency arbitrator, and that means I will not cover in any details questions of enforceability or the choice that the parties may have between bringing the interim request for relief before a local court or an emergency arbitrator. I will, though, briefly comment on a couple of court decisions from India and Singapore regarding enforceability of emergency arbitrator decisions that will come at the very end of my speech. I have decided to divide my speech into 5 topics. First, what is emergency arbitration? Second, what is interim relief? 3, what are the pertinent procedural rules governing emergency arbitrations? And then we'll turn to the bulk of the speech will be how to conduct an emergency arbitration, and not least, what are the substantive rules relevant for deciding an application for interim relief. The first issue is what is emergency arbitration, and as you will probably know, emergency arbitrations concern requests for interim relief. Emergency arbitrations are a relatively recent phenomenon in international commercial arbitration. I think the first of the major arbitral institutions to include provisions on emergency arbitration was the ICDR in 2006, followed by the SCC, Stockholm Chamber of Commerce, and SIAC, Singapore International Arbitration. In 2010, the ICC in 2012, HKIAC in 2013, and the LCAA in 2014. Today, all the major institutions have more or less similar provisions included in their rules or appendices to these rules. And the IAMC in Article 22(1) and Schedule 1 also include emergency arbitration provisions. Emergency arbitrations are born out of the acknowledgement that a party may reasonably need interim relief prior to the constitution of the arbitral tribunal itself, which may, as you will probably know, take months, depending on arbitrator candidate availability, the execution of list procedures, challenges to arbitrators based on perceived conflict of interest, etc., etc. So instead of forcing a party to go to the courts for such interim relief, i.e. prior to the constitution of the tribunal, emergency arbitration proceedings were established. The second issue is, what is interim relief? Interim relief or interim measures is not a term of art, but the 2006 Unravelled Model Law on International Arbitration was amended to include provisions regarding interim measures. And in Article 17(2), it says as follows: an interim measure is any temporary measure, whether in form of an award or in any other form, by which at any time prior to the issuance of the award by which the dispute is finally decided, the arbitral tribunal orders a party to A, maintain or restore the status quo pending determination of the dispute, B, take action that will prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself, provide a means of preserving assets, C, provide a means of preserving assets out of which a subsequent award may be satisfied, or D, preserve evidence that may be relevant and material to the resolution of the dispute. The key adjective is temporary. That means it's not a final decision on any part of the arbitration. It is a measure that is meant to support the arbitration proceedings in terms of assisting either procedurally, preserving evidence, substantively, preventing a party from taking action that may infringe the ultimate result, or facilitate enforcement, securing assets for satisfaction of a monetary award. That begs the question, which types of requests for interim reliefs are regularly put before the emergency arbitrators? In my experience, most often the request relates to the respondent being required not to do something or do something. And in my experience, the first type of requests are the most common, i.e. the applicant seeks to obtain a kind of injunction prohibiting the respondent to carry out a threatened or perceived threatened action. Typical instances will be attempts to prevent a respondent to make a payment request related to a performance bond, typically the so-called on-demand bonds. Prevent the respondent to encash a post-dated check if you're in the Middle East. Prevent the respondent from selling an asset or goods to a third party. I have encountered requests relating to dry docks and special carrier vessels. Or to make certain or prevent the respondent from making certain decisions as shareholders at a shareholder meeting. An example I have encountered as an emergency arbitrator was an applicant seeking to prevent a majority shareholder from voting through a decision to increase the capital of the company, whereby the majority shareholder would be diluting the more impecunious minority shareholder applicant's holding of shares in the company. It can also relate to requesting the respondent party to continue supplying the applicant with goods or services in the party's agreement, which has purportedly been terminated by the respondent seller or service provider, but the relevance of or lawfulness of that termination is denied by the applicant and is at the center of the arbitrations. These are just, of course, non-exhaustive examples of the interim relief sought by the applicant. Item number 3, what are the pertinent procedural rules governing emergency arbitrations? Some emergency arbitrations require that the applicant submits a request for arbitration either simultaneous with or prior to the applications. Other rules require that the request for arbitrations is submitted within a certain time following an EA order, an emergency arbitration decision granting interim relief. The rules typically prescribe that the emergency arbitrator must be appointed within typically 48 hours of receipt of the application. So therefore, arbitral institutions regularly send out invitations or inquiries to a number of potential emergency arbitrators regarding their availability and conflict of interest issues. And the one who first provides a positive answer normally gets appointed as emergency arbitrator. A third pertinent rule relating to emergency arbitration proceedings will be that the emergency arbitrator must reach out to the parties and establish a procedural timetable for the emergency arbitrator proceedings within 48 hours of his or her appointment. This can, in fact, in practice, be quite a challenging task, since emergency arbitrations are frequently commenced close to the weekend, and you very often get appointed on a Thursday evening or Friday, meaning that you will have to try and establish a timetable by Saturday or Sunday. Also, emergency arbitration rules of the various institutions include a rule that the decision by the emergency arbitrator must be rendered typically either 14 or 15 days following the appointment of the emergency arbitrator. However, the rules of the SEC, the Stockholm Chamber of Commerce, are a bit of an outlier, since they include a 5-day time limit for the decision. That 5-day time limit is frequently extended, but it does require the arbitrator to engage in rather robust case management in order to comply with time limits of the various institutions. How do you conduct an emergency arbitration? I personally think that emergency arbitration proceedings are very interesting, and they are a lot of fun. That probably shows that I'm a nerd when it comes to, unashamed nerd when it comes to being an arbitrator and legal matters, but they do require a lot of work over a very short period of time. They are, in other words, immensely intense proceedings. My shortest emergency arbitrator proceeding, which was in fact the first ever emergency arbitration by that institute, that lasted from Friday to Sunday. The application concerned the applicant contractor's attempt to prevent the respondent employer from making a request for payment under an on-demand bond in an major engineering project. That decision had to be made and rendered before the banks opened on Monday. Hence, there was a rush, and with the cooperation of both parties, we managed to conduct the whole emergency arbitration, including rendering the decision in a little more than 48 hours. At its core, you can say that conducting an emergency arbitration involves dealing with the friction between speed and due process. And what do I mean by that? By that, I mean that the emergency arbitrator must establish a procedural timetable that allows both parties a reasonable opportunity to present their case, but also allows the emergency arbitrator to render a decision quickly, i.e. typically between 5 and 15 days after the appointment of the emergency arbitrator. And that obviously puts considerable pressure on the parties, not least the respondent party, since you can say that the preparation of the application by the applicant can be done without the pressure of time, but that is not entirely true. Because the urgency of the matter, which I will return to, will often entail that even the applicant is under considerable time pressure for preparation of the application and submitting the application to the arbitral institution. As a matter of general application, I will always seek to grant each party the opportunity to make two submissions, i.e. the application by the applicant, the response by the respondent, a reply by the applicant, and a rejoinder by the respondent. Most often, a hearing involving oral submissions are not included in the timetable, but occasionally the parties will request the opportunity to make oral submissions. Most often, expert evidence is not tendered, and witness evidence is limited. I have had emergency arbitrations that included expert evidence. I have here now on my screen I'm trying to see if I can share it with you. I have here let's see if I do this. Is there any way I can share my screen so I can show a typical timetable, and then afterwards I will show a more expanded timetable from a couple of my emergency arbitration? How can we do that?
Yes, sir. I'm sure I have enabled the screen share option for you.
Otherwise, I can.
I think you'll be able to share the screen now.
I should be able to do so?
Yes, sir.
What do I do? Do you see it? I can see it.
Yes, sir. We can see.
Okay.
It's visible.
This is a typical procedural timetable in one of my arbitrations. This is actually, as you can probably tell from the timeline, this is in Stockholm Chamber of Commerce SCC matter. So I was appointed on the 10th of June in that particular year, and I sent out the first email 3 hours later. And the next day at 9 o'clock in the evening, the response to the application was supposed to be submitted. The next day, 24 hours later, the reply. The next day, 24 hours later, a rejoinder, and then 4 hours, sorry, after the rejoinder, we had the cutoff time. The following day, at the same day at noon, we had skeleton arguments. 2 hours later, cost submissions. And 2 hours following that, we had comments on cost submissions. And the next day, I rendered the decision, which ran to 45 pages. A slightly more, let's see. Work on that. This is another matter. I was appointed on that one on the 9th of February. I sent out the first email 3 hours later. Then there was again a response the next day. Then we had 2 case management conferences. There was an application for a preliminary stay order. And then there was the response to the application. Decision on the application of the preliminary order. There were memorials submitted by the parties, and they included expert evidence. They were cut off. We had skeleton arguments, and then we had a 6-hour hearing by video link where people were calling in from various parts of the world. And then on the 26th, I rendered the decision, which was in the form of an award. It was a rather complicated matter with I think it was five different requests for interim relief. Some of them were granted, some of them were not. As you can see here, in this case, we had to request an extension of the 2-week time limit by a couple of days. I am now turning to the substantive rules relevant for deciding an emergency arbitrator application, which, in my opinion, is the most interesting question that concerns the substantive criteria relevant for the emergency arbitrator when making his or her decision. And again, turning to the model law, the arbitral model law, Article 17A(1), includes the following. The party requesting an interim measure shall satisfy the tribunal that A, harm not adequately reparable by an award of damages is likely to result if the measure is not ordered, and such harm substantially outweighs the harm that is likely to result to the party against whom the measure is directed if the measure is granted. And B, there's a reasonable possibility that the requesting party will succeed on the merits of the claim. The determination of this possibility shall not affect the discretion of the arbitral tribunal in making any subsequent determination. In my opinion, I think a consensus has emerged in this respect. A decision by the emergency arbitrator will include deciding the following issues or conditions, and there are 5 of them. One is procedural, that the emergency arbitrator needs to have prima facie jurisdiction, or fumus bonae jurisdictionis, as it's called in Latin. The second issue is what was also highlighted in the model law. There should be a reasonable likelihood of success on the merits, fumus boni juris in Latin. The third issue concerns urgency. The fourth issue concerns harm not reparable by damages or irreparable harm. And the fifth concerns proportionality, which is also mentioned in the model law 17A(1). It's pertinent to understand that all these conditions are cumulative, they are not alternative. In other words, the applicant will have to prevail on all 5 issues. Otherwise, the application must fail. The first one is you can call it a threshold issue, is the one concerning jurisdiction. I have rarely seen that debated in any of the cases I have been involved in. I did once encounter an objection stating that granting the interim relief of preventing a seller from terminating a contract would de facto constitute a final decision. For various reasons, that objection was not successful. The second criterion is the reasonable likelihood of success on the merits, the fumus boni juris. And it is, in this regard, it is well established that the emergency arbitrator, without prejudging any part of the party's dispute, must assess prima facie the likelihood of the applicant's ultimate success on the merits. In English, under English law, it's often condensed to there needs to be quote, a serious issue to be tried, unquote. In most cases that I'm involved in, the likelihood of whether the applicant will ultimately prevail on the merits will require an in-depth consideration of the party's contract and the other relevant part of the factual matrix. And that will in turn likely require review of further evidence, including testimony by fact witnesses, documentary evidence, and expert testimony, as well as detailed considerations of the applicable legal principles including pertinent case law and persuasive precedents and doctrine. And it is not the function of the emergency arbitrator to attempt to assess the merits of the case or to form a final opinion about the likely outcome of the case. The emergency arbitrators, as we went through before, has only a few days or at the maximum a couple of weeks to determine a request for emergency interim measure, and he or she must make the decision on whether or not to grant the requested measure in the blink of an eye, or as it's called in Latin, in ictu oculi. Under these circumstances, it is enough that the applicant has a reasonably arguable case on the merits, meaning that if the claim is clearly without merit or clearly spurious, then that threshold is not met. Otherwise, the bar for a prima facie assessment cannot be set too high, or that would, for most practical matters, entail that emergency interim relief would only be available in cases that are very simple from both a factual and a legal point of view. That would entail that setting the bar in respect of the applicant's ultimate success too high would exclude parties in many, if not most, commercial contractual arrangements of some complexity from availing themselves of the emergency interim relief regime that have been adopted by all the leading arbitral institutions. So far, I have not denied emergency interim relief based on lack of a reasonably arguable case. The third criterion is urgency. It is well established that the question of urgency must be answered by assessing whether or not the requested emergency relief can reasonably await the constitution of the arbitral tribunal in the pending arbitration between the parties, and thereby have the arbitral tribunal determine a similar request for interim measures. In my opinion, the matter of urgency must be assessed at the time of the emergency arbitrator's decision. That means that if matters transpire after filing of the application for emergency relief that impacts the urgency of the request for relief, the emergency arbitrators is entitled to take such subsequent events into consideration. A question which often comes up quite often comes up in emergency arbitration is the one whether or not a self-inflicted urgency, in the sense that a party waits until the very last moment to file an application for emergency measures in a situation where the potential emergency relied on has been known for some time, can obliterate the emergency for the purposes of emergency arbitrations. I think it's a relevant consideration, and I have so far not reached the conclusion that a self-inflicted urgency should bar the emergency relief requested. But it is something that is worth considering in I wouldn't say an extreme case, but something that could impact the urgency consideration, in my opinion. Number 4 is the question of irreparable harm. And the fourth criterion, it is generally accepted that an order for an interim measure should be granted only if the applicant demonstrates that it may suffer irreparable damage or injury in the absence of the requested interim measure. Although the level of harm necessary to satisfy this requirement will often be difficult to quantify, at its core, irreparable harm typically refers to an injury that cannot be compensated by the way of a damages. This means that where the dispute only involves a monetary claim, but not any kind of other performance, it may be difficult to convince the emergency arbitrator that an interim relief is relevant or urgent or or satisfy the criterion of irreparable harm, unless some evidence is tendered that would suggest or could suggest that the respondent either is not able to satisfy an adverse award, or that the respondent may repatriate funds or in other ways make it difficult for the applicant to enforce an award in its favor. And I have read a couple of paragraphs from one of my decisions in this regarding the question of irreparable harm. I have blocked out or blanked out a few of the giveaways regarding what the dispute was about, but I will read it for you, and that, in my opinion, that demonstrates my way of thinking. This is paragraph 98 of the award. The parties and the expert disagree whether the particular object is a rarity in today's market for that particular object. It's not the role of the emergency arbitrator to attempt to decide this issue with any degree of finality. Suffice it to say that it would appear to the arbitrator that the object is among the first in a new generation of small, advanced, and very flexible that can be employed in several ways and serve multiple purposes. Paragraph 99, moreover, the object undoubtedly falls under the category of specific goods. And then paragraph 100, under these circumstances, the emergency arbitrator will therefore proceed on the assumption that the object cannot be replaced by another similar object readily available in the market. And 101, if the respondent terminates the contract or the production of this particular object and instead sells and delivers the object to a third-party buyer, it is doubtful whether the applicant will be able to exercise any ownership right to the object against the third-party buyer should the applicant ultimately prevail in the arbitration against the respondent. This in turn entails that if such delivery to a third party takes place and it's later determined by the arbitral tribunal once constituted that the termination of the contract was wrongful, the applicant may face considerable difficulties in asserting any ownership rights in rem regarding the object. The question of ownership rights in rem is a complicated legal question, which it is plainly not for the emergency arbitrator to determine under the emergency arbitrator proceedings. Also, that's 102, that's the final paragraph that I will read to you. Also, the emergency arbitrator notes that under clause such and such of the contract, the parties appear to have excluded certain categories of loss from being recoverable as damages. This provision may work to the detriment of the applicant in a scenario where the applicant prevails in the arbitration against the respondent, but the respondent has terminated the contract and sold the object to a third party. In conclusion, based on the above consideration, the emergency arbitrator finds that the threshold for harm not reparable by damages, irreparable harm, is met. The final issue to be considered by the emergency arbitrator is the question of proportionality, which is also included in Article 17A(1) of the model law. And that requires or involves a decision by the emergency arbitrator weighing the potential or likely harm caused to the respondent if the emergency measure is granted against the potential or likely harm to the applicant if the requested emergency relief is not granted. It is also known as the balancing of the interests of the parties when addressing requests for emergency measures. It is an individual and it is a fact-intensive exercise. However, as a point of departure, if granting the interim relief would interfere with a contractual arrangement that the parties have put in place by virtue of their contract, the interest of the respondent in contract adherence will typically outweigh the applicant's interest in the requested interim measure. As an example, I return to the on-demand bond guarantees. If an applicant had seeking the interim relief that the emergency arbitrators injunct or prohibits the beneficiary of the bond from making a demand of payment under the bond, if the applicant had wished to protect itself from such a behavior, calling on the bond, it could have insisted on a different contractual mechanism. It could have, for instance, that the guarantees were not issued on an on-demand basis, or that a subsequent notice by an objection notice by the applicant, or the applicant commencing arbitration proceedings within a certain amount of time, would entail that the payment under the on-demand bond would be stayed. So, as a point of departure, the contractual arrangements between the parties must be considered as a calculated risk taken by the parties themselves, and that will typically, in my opinion, entail that the contractual arrangement should be upheld, and it's not for the emergency arbitrators to interfere in the contractual arrangements between the parties. These are the issues that you should consider when sitting as an emergency arbitrator and dealing with the request for emergency review. Turning then very briefly to what I would call post-emergency arbitrator issues, namely recognition and enforcement of emergency arbitrations. The model law, Article 17H, has a provision concerning recognition and enforcement of interim relief. In terms of emergency arbitrator relief, I noticed when I was preparing for this speech, I reviewed if there was any case law that could be a particular relevance to you, and I did notice that the Supreme Court of India, in the civil appeal number 4492 and 4493 of 2021, in a case between Amazon and Future Retail, decided that an emergency arbitration under the SIAC rules, SIAC rules, was enforceable, and based that on a number of provisions in the Indian Arbitration Act, namely Section 2, that has the definitions part where it says, in this part, unless the context otherwise requires. It was said that an arbitral award includes an interim award. In just a second, in section section 17, section 17, where you have interim measures ordered by the tribunal, it is said that in 17.2 that subject to any orders passed so and so, an order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purposes. It shall be enforceable. And the Indian Supreme Court placed a lot of emphasis on party autonomy, and stating by agreeing to the SIAC arbitration rules, that's how I understand it, I only read it cursorily, by agreeing to SIAC arbitration rule, they agreed that the emergency arbitrator and the emergency arbitrator decisions should be considered as awards for the purpose of the Indian Arbitration Act, and thereby also being enforceable. I can refer you to its page 35 and 36, I think in particular, of the decision that is of interest and espouses this principle. Another case is from the court of the High Court of Singapore. It's the reference is 2022 SGHC 249 between two parties, CVG versus CVH. And in this decision, the Singapore High Court also decided that an emergency decision award by an emergency arbitrator was in principle enforceable, because, but that was simply because that the International Commercial Arbitration Act, the International Arbitration Act of Singapore, has made some amendments in Article 2 and 27. And so 212 and 27, that entails that emergency arbitrations, emergency arbitrator decisions awards are enforceable. That in that particular case, though, the enforcement was denied due to the emergency arbitrator apparently had failed to allow the parties, both parties, a reasonable opportunity to present its case. Those were the my introductory remarks, and I'm happy to take any questions if anybody has a question.
The first question is, can oral application be allowed, especially between parties where countries allow oral contracts?
Excuse me? If the parties allow oral contracts?
So can oral application be allowed between parties where countries allow oral contracts?
I'm not sure what you mean by oral applications. I mean,
Oral applications, oral emergency applications. I think that is what I can gather from the question.
I mean, the rules, I mean, in my country of nationality, oral contracts are perfectly legal, but you can apply for emergency relief there. Of course, you will have there will often be an evidentiary issue related to what was the content of the oral agreement. But I don't see any particular obstacles to that. Of course, you will need to comply with the rules in terms of making the application in writing and so on and so on.
So my question to you is, what are the ethical considerations that an emergency arbitrator must keep in his mind and maintain impartiality as well as ensure fairness while handling urgent interim relief applications, as well as if he's the same arbitrator even in the subsequent arbitral proceedings?
It's important to, it's a good question, thank you. It's important to understand that the subsequent arbitral tribunal then constitute is not in any way bound by the decision of the emergency arbitrator. They may vary or annul the decision, they or may also uphold it. The ethical considerations are the same as in, I would say, in any other arbitration, is that you need to maintain your impartiality, and you need to. This is also what I'm saying. It's not your job to make a final decision or even attempt to make a final decision on the merits. You are only requested and required to apply yourself to considering the 5 issues that I went through before. And if they lead you to that the interim relief should be granted, then you will grant it, otherwise not.
The next question in the chat box is this emergency arbitration applicable for violation or infringement of intellectual property rights, particularly patent rights, or is it restricted to commercial transactions?
Well, if the to the extent that that's a question of arbitrability, I would say. To the extent that the dispute itself is arbitrable, my opinion would be that an emergency arbitrator, a request for emergency relief that does not go beyond what is arbitrable will be available to the parties.
The next question is, how likely is that the emergency arbitrator is caught in biasness or prejudice against one of the parties in the dispute?
Well, hopefully it's out of the question. It should be out of the question, but obviously it's no different than any other arbitration that some arbitrators and some emergency arbitrators may have some kind of acknowledged or latent bias, but I certainly hope not. It's your job to, like it is as an arbitrator, to consider the facts and apply the law as you see it to those facts.
So the balancing of interests is done even in courts when they grant interim reliefs. So how is emergency arbitration different from interim reliefs, especially in terms of speed, enforceability, and flexibility?
Well, it's not. It is emergency arbitration is interim relief. It concerns interim relief, and the balancing of the proportionality and the balancing of interests are, as I said before, it's a fact intensive. It's hard to decide it, to explain more in the abstract. It's very fact sensitive. But as I said, if you have a contractual arrangement, you need to consider whether you are interfering in the party's contractual arrangement by granting the interim relief. I noticed that here there is a bit of a divide. I heard that from a counsel from the ICC, who had noticed that civil law trained arbitrators were more likely to grant relief even when it contradicted the parties' contractual arrangements, which I find quite astonishing, I have to say. Even though I'm originally a civil lawyer, in this context, I'm very much a contract adherence lawyer and arbitrator, such as an arbitrator.
My next question to you is, can we file an appeal against an emergency award or emergency relief? I think that's the question.
You can not file an appeal. You can appeal to the emergency arbitrator, but you can appeal. What you can do is that you can try and have it set aside, I think, by the courts. That's a good question. Now that would be an enforcement situation, but as I said, the arbitral tribunal, you can appeal to the arbitral tribunal and request that the tribunal, once constituted, changes, amends, or annuls the decision by the emergency arbitrator. So that kind of appeal you do.
Okay. So the next question is, how would you approach balancing the need for speed in emergency arbitration while ensuring a just process for the parties involved? And what are a few tips young practitioners need to keep in mind in the same approach?
Oh, that's a good question. As I said, this is the whole or the main purpose of when you conduct the emergency arbitration, is that you need to address the friction between speed and due process. So you need to allow the parties a reasonable opportunity to present their case, whilst also, since the parties have agreed to the emergency arbitrator proceedings by agreeing to by virtue of the arbitration, they also need to comply and understand that these are the rules for emergency relief. So as I said, what you should do is it's the same as in any other arbitration. You need to give the parties an equal opportunity, and it has to be reasonable in the sense that they have to be able to present their case. But the parties will have to understand that the time limits will be narrow, and it will be very, very labor intensive also on the parts of counsel, not only the arbitrator.
How is an emergency arbitrator? Okay, no, that's not the question. Sorry. Is an emergency arbitrator required to be the expert of a given domain in an industry?
No.
What if the particular case or the application concerns a particular domain that needs to be addressed?
Well, that's of course if an emergency arbitrator considers himself or herself incapable of dealing with that particular case because you lack of competencies, that you will have to decline being appointed. But otherwise, these are all contract disputes. within various industries.
Okay, so moving on to the next question. When there is a jurisdictional challenge, whether the emergency arbitrator needs to address the jurisdictional issue first and then proceed with the emergency application proceeding, or can he proceed without hearing the jurisdictional challenge?
No, I don't think so. I think you have to address that as a threshold issue. You need to decide that first, because I mean, if you don't have jurisdiction, there's no need to continue with your considerations of the application.
So there is a doubt here which says if the interim emergency arbitration award is different from the actual arbitration award, then what are the consequences of the interim arbitration emergency arbitration award if there are any damages or losses done to the other party because of the interim award?
And to say this is no difference than if you have well, the emergency arbitrator does not decide the dispute itself. The substantive dispute is not decided by the emergency arbitrator. He or she should not even try to decide it. The emergency arbitrator's only function is to step in the shoes of the arbitral the tribunal before the tribunal is formed, and try to assist the tribunal as he or she best can by trying to make a reasoned decision regarding the interim measure requested. If, as I said, there is the arbitral tribunal is not bound by the decision by the emergency arbitrator and can vary or annul the decision as the arbitral tribunal sees fit. I cannot completely rule out that if something is done in bad faith by the emergency arbitrator, then there could be an issue of damages. But otherwise, it's no different than various judges on the same panel or between different court of appeals. They may disagree on various matters. That doesn't entail that the judge whose decision is ultimately set aside is liable in damages.
Do we need to have an express clause on emergency arbitration in the arbitration clause or agreement? And since it is an emergency arbitration, how are the issues of appointment of arbitrator taken care of?
Sorry, there was a helicopter, there's a seaplane flying by me just outside. Could you just, I didn't hear the last part of the question. Could you repeat, please?
Sure. Do we need to have an express clause on emergency arbitration in arbitration clause or agreement? And since it is an emergency arbitration, how are the issues of appointment of arbitrator taken care of?
If your arbitration agreement involves referring the disputes to an arbitral institution, the rules of which include emergency arbitrator provisions, then you do not need a reference to that particular institution like SIC, IAMC, or whatever institution you choose. But you need to look out if they have emergency arbitration. Normally, I think by now, all of them will have emergency arbitration provisions. And in terms of the appointment, that's taken care of by the arbitral institution. They, as I said, they send out, normally they send out, because it's a matter of speed, time is of the essence. They normally send out requests or inquiries to more than one potential arbitrator, emergency arbitrator.
So how long this emergency arbitral award would be applicable? For example, is it throughout the arbitration proceedings or just for the just till the next date of arbitration?
That depends on the. I mean, you can have. I have issued granted emergency relief limited to a certain time. In some arbitral institutions, you have you have granted the interim relief, you need to you may need to submit the case to arbitration if you haven't already done that within 30 days or so. Otherwise, they will fall away. And otherwise, it will remain in force until varied, amended, or set aside, or by the arbitral tribunal once constituted. That's the main goal.
Okay. And do you see emergency arbitration as an additional cost incurring process?
What do I say? Sorry.
Do you see emergency arbitration as an additional cost incurring process?
Yeah, absolutely. It involves costs. Often, what you do as an emergency arbitrator in some rules, you are not supposed to determine the cost of the application. Under some rules, you may determine the cost of the application. Quite often, you say that's for the arbitral tribunal once to ultimately decide on the cost also of the emergency arbitrator applications. But obviously, since there are procedural steps to be undertaken by counsel and by the arbitrator and by the arbitral institutions, it will involve costs. The costs are different. Normally, you are paid. I think in all the rules I know, there is a fixed fee for the arbitrator, for the emergency arbitrator. So it's not ad valorem. It's not based on the amount of time you spent on it. It's simply a fixed fee of a certain amount that you are paid.
So is there a requirement for an emergency arbitral award to be in line with the final award? Because there is a question in the chat box which says that this is the principle which is generally followed by civil courts while granting interim reliefs.
If there is as I said, it is interim relief, and so it doesn't have, and it can be set aside. It's emergency interim relief. It only applies until the arbitral tribunal is appointed and has the opportunity by an application of either party to set it aside, reconsider it. So in that sense, the answer to the question is no.
Yeah. So if any additional evidence is available from the parties, and in that scenario, does the emergency arbitrator reconsider its interim relief? Or, after the emergency arbitration has suspended, does the arbitration tribunal have the power to sit as an emergency arbitrator again to consider the emergency interim relief granted in light of the additional evidence?
You can. The most of the rules, they include an opportunity to reapply and have the emergency arbitrator reconsider an issue if new and pertinent evidence are at hand and are tendered.
I think we'll go with the last question for the day. Are emergency arbitrators and arbitrators during arbitration proceedings, do they remain the same?
No, an emergency arbitrator will never be able to sit as an arbitrator in dispute.
Thank you so much, sir, for joining us today and sharing your invaluable insights with us. It has been one of the most enjoyable and most learning sessions, and I'm sure the participants, they have learned a lot from you today.
Thank you. It was my pleasure. Thank you. Have a nice evening all.
Have a nice day to you too, sir.
Bye-bye.
Bye-bye, sir.